Bueno, muy buenas tardes. Un gusto saludarlos a todos. Esta carta náutica va a ser en inglés, así que we're gonna switch to English now to welcome our friend and special guest of today, our great colleague from New York, Vincent Foley. Vincent is a partner in Holland Knight at the New York office. So, welcome again, I think, because actually this is your second time in Carta Nautica, right, Vincent?
Yes,
How are
that's
you?
right. Thank you very much, Javier. Always happy to discuss maritime law issues with my friends in Colombia and around the world. I see a lot of familiar names here have signed on, including Jonathan Spencer, who's an average adjuster here in New York. Um, and yeah, general average is always a topic of great interest. It comes into play usually whenever you have a large casualty. There are some aspects that involve general average. So I am when you offered that as a topic, I thought it would be an interesting thing to cover, especially in view of the very large bridge that came down when the MV Dali was just trying to get out on to start its voyage.
Yeah, sure. So, I mean, it's a tragedy, but before we move on to that, why don't you tell us a little bit about your practice in New York? What are you doing at the moment? I mean, what are the current maritime US law? Where is it going?
I wish I knew. I wish I knew. So I'm based in New York, and I do mostly maritime law. My background is that I worked on ships before I went to law school, and then when I graduated from Tulane University, I started working here actually about 27 years ago. Um, and I'm basically in the same firm, although it has changed quite a bit. We merged. We went from a small transportation boutique firm to
Mhm.
merging with Holland and Knight, and we have sort of a national platform all over the U.S. We have an office in Colombia, offices in Mexico City and London. The maritime practice primarily focuses on New York. We have the Society of Maritime Arbitrators here in New York. So if parties select New York arbitration and Society of Maritime Arbitrator rules for their contracts, we can resolve those disputes here. And we have our federal courts where most of the maritime litigation takes place because maritime litigation is international litigation. And when the founders of our country drafted the Constitution, they included the Admiralty or maritime law in the federal issues that would be addressed by the federal judiciary. Um, so the issues that are compelling right now for maritime law, it's hard to say. There are a number of issues that are up with our Supreme Court every year, and I don't have one that we've had a recent decision on that comes to mind. You'll recall a few years ago, I think the last time I was here for Carta Nautica, we had a Supreme Court
Yeah,
decision on the definition of a vessel,
yeah, the
and that was
Osman case, right?
that's where they took a houseboat and they said, well, that
Yeah,
was not supposed to be a vessel. It wasn't built or designed to be a vessel.
yeah.
So that's how we're going to structure our new definition, um, which I met with some criticism as to the approach uh, to apply the same rule for a small houseboat that you would apply to, say, like a mobile offshore drilling unit, and then try to define where vessel lies in between there. Um, So I mean, that's basically where what's happening here in New York.
Yeah. Yeah, yeah. No, but thank you for that overview. And I do remember our conversation on the Losman case, an interesting one. But here we're today to talk about a different case, the MB Dali or Dali. And a lot of people is asking, about the title of our session. What is an elision? Probably for a maritime lawyer is something that we already know, but I think we need to clear the water
Yeah, sure. And elision, it's an unusual word that, a lot of people who are not involved in maritime cases are just not familiar with. I mean, the word that is more familiar for us is collision, Collision, and that's when there are two moving parties, two moving objects that collide. So that's something that's familiar, car crash, um, you know, anything where you have two moving objects. So an allision is where there's one moving object and one stationary object.
Mhm.
And the law in the US, maritime law, provides a presumption of fault on behalf of the moving vessel that strikes a stationary vessel. Because if you're stationary, really, you're typically not the party that has caused the incident. So there's a presumption in the law that you're at fault unless you can show that you're free from fault. And so the burden falls on the moving vessel to show that they
Mhm.
were free of fault for that particular incident. So when you have a case where the MV Dolly is a moving vessel that's proceeding, out to sea under the Francis Scott Key Bridge, the bridge is typically, you know, in the right there. The vessel's supposed to not hit the bridge when it goes through. And here there was a loss of power and an elision against the bridge with dramatic effects, losing the whole bridge, the whole length of the span of the bridge into, the Chesapeake Bay waters. Um, so the other thing with an elision is if the ship owner can show that that bridge should not have been there, if there
Mm.
was permitting that was required and the bridge wasn't high enough or wasn't built in, to the dimensions that the permit required, that part of the bridge could be considered an obstruction to navigation. And that would allow the ship owner to shift some of that burden, that fault back to a stationary object if, for example, a pipeline or a terminal or even a bridge were constructed in a way that was not authorized by the regulatory authorities, uh, that bridge could become at least proportionately have part of the fault for an elision like this.
Yeah. Okay. And I mean, what in general terms what in general terms is a general average? I mean, this is a term we use a lot in the maritime world, but how can you describe in simple terms for our audience the concept of general average?
Yeah, general averages, it's an ancient maritime principle. I mean, it goes back thousands of years before they really had domestic laws in individual countries. And it is based on sharing a loss, sharing a common loss that is encountered uh, during a maritime venture.
Mhm.
Typically, the parties to the maritime venture are the owner and the cargo interests, and the freight or the amount due to transport the cargo has also become one of the major the main three parties to a that would have to contribute to a general average. So
Mhm.
the typical situation is if you have a voyage with a vessel at sea with cargo on board, the vessel gets into a rough storm where
Mhm.
it's compromised, right? It might sink. They have to make
Mhm.
a decision to jettison part of the cargo, and they have to decide, what's the best cargo to discharge. Um, when that happens, you discharge the cargo and it saves the vessel, and the vessel then continues on the voyage. The idea is that that sole cargo owner should not have to bear the full expense
Mhm.
for the loss, but that loss can be shared by other interests on the voyage that received a benefit. So if they have a common benefit, that can be a common expense. So the general part of the average is that it's shared by the participants to the voyage. That's a general average. Now, if there is an accident where uh, the vessel itself runs into the bridge,
Mhm.
that's a particular average. That's usually caused by something the navigation of the vessel, the operation of the vessel, and a particular average is just for that one party that was responsible. And in that case, in the case they have a grounding, that would be typically the ship owner.
Yeah, it's based on the idea of well, common benefit, and you know, the idea of navigation being just an adventure, right, for everyone involved, basically. But
Yeah.
what are the main requirements on
Well, the
their?
voyage is what everybody's involved in, right?
Yeah,
Everybody wants the cargo to get to destination. So if something happens along the way, that
yeah,
sacrifice is part of the voyage. And that expense has to be made good to those participants so they can continue the voyage and get the cargo to destination. Then the
yeah,
cargo's happy, the ship gets paid its freight, and you know they share in the loss.
yeah. They are sharing the loss in between all the parties who actually benefit from the
Right.
situation. What are the main requirements of the on their, you know, general maritime law for this institution to be able to actually, you know, operate?
There has to be a general average act, and that general average act is the sacrifice. You know, something that is voluntarily and given in order to save the other participants.
Mhm.
So it has to be a general average act. It has to be voluntary um, and successful, right? If you uh, discharge the cargo and the vessel sinks anyway, you're not getting general average, right? You didn't save anything. And that sacrifice has to be for the common benefit of the parties to the joint venture or the voyage. And then you have the ingredients for a general average claim to take place.
Yeah, yeah. Okay, and how can general average incidents be of, you know, importance in big maritime casualties such as this one? Because sometimes, you know, we hear a lot about all these requirements, specifically, you know, the sacrifice, which, as you have said, must be more voluntarily in nature, right? So how can be these kind of, you know, situations actually applicable to a case like this one?
Well, general average is usually helpful when you want to continue the voyage,
Mhm.
because when something like this happens, like the Dolly runs into the bridge, and there's a major damage to the bridge, and the vessel is delayed for a number of months to clear itself from the bridge, to be salvaged, have containers taken off, repairs undertaken. The owner is entitled to just declare the voyage at an end, and
Mhm.
and have the cargo left at the port of refuge for all of the cargo interests to come and pick up and ship off to their different locations. So if you can, if you have a general average, you can declare general average and incur some common expenses like the salvage, the repair of the vessel, um, transshipment of the cargo to destination. So there are more options available to complete the voyage by making these common expenditures. You know, so that's where it comes into play as being helpful to get the voyages completed to the extent possible in the face of, you know, a terrible tragedy like what happened with the bridge
Yeah.
and the
Yeah.
MV Dolly.
Yeah, a tragedy indeed. Probably you have already mentioned it, but just to be, you know, completely clear, and for the people who are actually listening to this to have, you know, some takeaways very clear, what kind of damages are to be recoverable in a situation like this? Because obviously you have a lot of damages involved in a situation like this, but probably you want to know what kind of damages or what is the nature of the damage that should be, you know,
Yeah.
that can be actually be recoverable.
Okay. Well, yeah, sure. Well, here we have the owner and we have a charterer, Maersk Line. And you know, so the owner has chartered the vessel to Maersk Line. Maersk Line has entered all the bills of lading with the thousands of cargo interests that have containers on board. So for the common losses or expenses that will help the cargo interests are like the salvage of the vessel. So you get the vessel off the bridge and to a port of refuge. The repairs, the transshipment, you're arranging to complete the voyage. Those kinds of expenses will all be part of a general average adjustment. So an average adjuster would look at all the different costs that are permissible under the general average rules and tally up the expenses that can be shared. And the ship owner is entitled to make those expenditures and being reimbursed by the cargo interests who have to post security in order to collect their cargo and have it discharged to them.
Mm. Okay, and let's move to the perspective of the, cargo owners. Cargo owners probably will just, go and enter into a carriage contract without not knowing about anything, not knowing anything about the, the general average institution. But how can be, of importance to them? What you as a maritime lawyer will say if a client, being just a cargo owner, will ask about, the institution and the implication under the contract carriage?
Well, it's important to the cargo owners because they are going to be asked to post security. I mean, they've already paid their freight, right? They really just want to get their cargo delivered, but they can't do that because of the interruption of the voyage by the general average incident.
Mm.
So they're going to have to either them or through if they have insurance, the insurance will usually step in to provide security and allow the cargo to be released to the cargo owners. If they don't have insurance, they're going to have to put money up based on the calculation of the allowable general average expenses, and pay that money to get their cargo released. So here is where the cargo interests who have purchased insurance really get a benefit, because they can sit back and say, all right, my insurance is going to handle this. And those parties that haven't procured insurance beforehand are going to have to do it themselves, or they're going to have to hire a company like a cargo recovery company like WK Webster is one that's working on the Dolly. I had an inquiry on that about a month and a half ago, and they will help cargo interests. They'll sometimes post security for cargo interests they get a fee for it, but they would expedite the process for a cargo interest that's really not familiar with how the process works in the aftermath of a large container ship casualty like this.
Yeah. And what about the perspective of the insurers? Do you think they have a different perspective? Probably they will have a look at this, from the very beginning, just even before.
I mean, for the insurers, it's they have to decide if it's a covered event, if it's insured by the policy. If it's a marine cargo policy, typically that's all risks, all losses. They will have to step up and pay the security for their assured. So they're not happy about it. I mean, I don't think insured interests are ever happy that they have to contribute to general average or pay the actual liability. But in the first instance, when the casualty actually happens, it's just a matter of posting a bond or posting the security.
Yeah,
the general average typically takes 4 to 5 years, or in a case like this with thousands of cargo interests, it could be longer than that, for the average adjuster to figure out all the details of the interests involved, the expenditures that were incurred, what was allowed under the general average rules in place. The bills of lading that the ship owner, in this case the charterer Maersk, issued will adopt specific general average rules, or the place of general average, for example, New York or London, and then the average adjusters will take over and make those calculations. But that's 5 years down the road. So if someone comes up to you in 5 years later and says, you owe me $10 million, usually not what you want to hear. Usually you would rather be done with that, at the time. So I think that for insurers, it's not a happy thing for them, but it's part of what they agreed to undertake.
Yeah, that's true. That's true. Well, and we recently read something you wrote about the whole situation of the Dali and how there could be some sort of discussions about the seaworthiness. So why we don't let's move on to this and discuss a little bit about the concept of seaworthiness, just for the people to have an idea of what the discussion is about. Probably some experts of the field that are with us today, they don't actually need that, but I think it's worth, for everyone in this scenario to get an idea of this. So what is this concept of seaworthiness involving under US maritime law?
Yeah, so the concept of unseaworthiness or the warranty of seaworthiness from the owner is it's a non-delegable duty that the owner will maintain the vessel in a condition fit for the intended voyage.
Yeah.
And when I say non-delegable, that means that the owner can't go and hire someone, a contractor, someone else, and say, well, I hired them, they should have done a good job. They should have made the vessel seaworthy. The owner undertakes to maintain the vessel in a seaworthy condition, and it's sort of a form of strict liability. That if the vessel is not in a seaworthy condition, the owner is going to be held responsible for that. And the way that comes into play when you have a casualty, like a bridge elision, is well, first of all, typically what the owner will do when the owner contracts with cargo interests, they'll say that we have this obligation, this warranty of seaworthiness, but what we're going to do is agree with you that we will exercise due diligence to make the vessel seaworthy at or prior to the time of the voyage. And if we do that, we should be entitled to the defenses in our bill of lading and whatever cargo carriage regime applies through the bill of lading usually. So if there is an unseaworthy condition that causes the grounding, for example, in this case, if there was a defective steering gear, right? That has typically been something that if that causes the vessel to veer off course and hit the bridge, that defective condition, that unseaworthy condition is the responsibility of the owner. And in that case, if the cargo interests can establish an unseaworthy condition that caused the grounding, they can convert the general average expenses that they have to pay a portion of into a particular average expense and say, well, the vessel was unseaworthy, so the owner is liable for all the damages, and there's no general average for cargo interests to contribute.
Yeah, that will change the whole picture, huh?
It shifts the responsibility to the vessel owner because he was operating a vessel in an unseaworthy condition.
Yeah.
It has another effect with respect to limitation of liability. It's very similar or the same thing. That in our case, we have the 1851 Ship Owners Limitation of Liability Act that allows the vessel owner to limit its liability to the post-incident value of the vessel, provided that the cause of the grounding was not within the privity and knowledge of the owner. And an unseaworthy condition, by definition, is within the privity and knowledge of the owner because it's an owner's responsibility. So if there's an unseaworthy condition, that could just deny the owner the right to limit liability and make them liable for the full amount of damages, which is generally a very substantial change from a post-incident limitation, the value of the vessel after it's been damaged, to the total loss for the damages.
Yeah, but I mean, just to be sure that I'm following you properly, because we traditionally hear about the due diligence obligation within the ambit of the due diligence obligation within the
Yes.
ambit of carriage of goods by sea and bills of lading. So how do you balance that, for a case like this? Because at the end, you will be looking at the general average within the ambit of, the contract carriage, right? And within the contract carriage, within the contract of carriage, you will have the discussion of the obligation of the ship owner, or the carrier. So at the end, what do you think is going to be important, whether it was in fact unseaworthy, or whether the owner didn't, or the carrier didn't exercise the due diligence required under the whatever
Well,
regime.
that really comes down to, who the party is, right? So if it's a cargo interest that's on board the vessel because the ship owner issued them a bill of lading and agreed to transport the cargo from load to discharge, in that bill of lading, they can reduce the warranty of seaworthiness down
Mhm,
to an obligation of due diligence. So
mhm.
that if the ship owner exercises due diligence to make the vessel seaworthy at the beginning of the voyage, he's entitled to the defenses in the bill of lading.
Yeah.
The other side is, say you're an innocent bridge that was just sitting there, minding its
Yeah.
own business, and the vessel hits the bridge. There's no
Contract.
contract between the bridge and the vessel owner. So the warranty so the obligation of the vessel owner in that case is at that warranty level that they have that the vessel was in a condition to be operated safely for the voyage, and there's not a due diligence standard. So it's just if there is an unseaworthy condition. So if the vessel was compromised, the owner is not entitled to his limitation of liability under our national limitation of liability rules. But those are two different things. The bill of lading governing responsibility, which can reduce the seaworthiness burden, and the regular tort litigation that allows for a limitation, but only if the vessel is seaworthy.
Yeah. Yeah, okay. And coming back again to what you have said about the limitation, and probably is, going back to what you have already mentioned, but still, I think it's worth it to invest the time on this. What could happen, in your view, if investigators end up establishing that there was actually a lack of seaworthiness of the ship in this case? I mean, you think actually they will be able to remove the limitation that is being set up, or that has
It
already
will
been?
definitely come into play when you have the National Transportation Safety Board and the U.S. Coast Guard convening formal boards of investigation right after the incident. They are going to take interviews of all the crew members. They're going to collect information from the interested parties, the owner, any suppliers to the vessel. In this case, one of the things that they looked at very early on was whether bad fuel was delivered, which could have interrupted the operation of the vessel's main engine.
Mm.
So that very intense investigation at the beginning of the case has the effect of sort of providing the parties the information that will help them resolve that dispute between themselves. So if a lot of the facts that normally take a while to develop, you have to wait until you do discovery and you sit down with depositions and you find out what really happened. All of that's coming out right at the beginning of the case. And there'll be a report from the NTSB that might just find that there was a defective condition that renders the vessel unseaworthy. And that would be a very difficult thing for the owner to have to overcome, because you know, when they do the Coast Guard and the NTSB investigations, they're putting a lot of resources into this, and they're really, you know, if they typically will identify those defective conditions that could be unseaworthy conditions early on. And that tends to shape the litigation that follows. So if you know that there's a problem and that it is unseaworthy and that came out in the NTSB investigation, you're probably going to approach your case differently than if there are a lot of unknowns, or if this, a case where you haven't had that kind of investigation.
Yeah. Let me ask you this, Vincent, because I was thinking about when you were, mentioning the NTSB investigation, which is the federal office, which is actually doing the investigation of the case. Is this report, because so far as I've seen, they have just released the preliminary report, right? So at some point in time, probably 1 year, 2 year, whatever, they will provide that definitive report or whatever, the final report. So
They will, yeah, they'll issue a final report. They'll have hearings before the National Transportation Safety Board, where they explain all the evidence that was available and they come to their conclusions. Now, but from a litigation point of view, that NTSB final report is not admissible.
Yeah,
it's not something that can be used as evidence in the case, because the purpose of doing the NTSB investigation is for the safety of transportation infrastructure, for persons that are traveling on the bridge or operating the vessels, and they want everyone to be as candid as possible. So there is a regulation that prevents use of the NTSB report as evidence. So that being said, those people are still there. The evidence is still there. You just have to get it from the participants on the ship, the crew, the Coast Guard involved, the suppliers and third parties, and other factual participants. And you have, but that NTSB report will give you a roadmap of where to go and who did what and what their conclusions were. And then you have to build that record by developing your litigation strategy, for liability or non-liability.
Yeah, whatever the party you are representing or whatever, you need to go and appoint the expert or whatever, right? To find your own conclusions, let's say.
Start with the factual witnesses, and then we get to the experts, and then get it all organized, and we put it in front of the judge.
Yeah. And coming back a little bit to what you have said also, previously, let's go back to the general average itself. We didn't actually mention, or we probably mentioned it, but not, let's say, develop the idea of the York-Antwerp rules. Why don't we explain, to people joining us today what implication they will probably have in a scenario like this one?
Well, the York-Antwerp rules are rules that have been developed over, again, centuries for the type of general average claims and the type of expenses that are allowable. I mean, I am not fully familiar with York-Antwerp rules and in chapter and verse. You'd have to get someone like Jonathan Spencer, who goes to sleep with a York-Antwerp set of rules under his pillow, probably. But those rules are usually selected in the contract of carriage. Yeah. So they will say York-Antwerp rules 1994. I think that's the most popular version right now. And then they'll say that the general average has to be adjusted in New York or in London according to those York-Antwerp rules. There are a number of, there are lettered rules and then numbered rules. And because I'm not familiar right now with the distinctions between those, but I'm pretty sure that the numbered rules are the different kinds of expenses that can be allowed in general average. And the average adjuster who takes up the case, who collects all the security from the cargo interests, they are going to apply those rules to the adjustment and allow claims, disallow claims, and then apportion responsibility between
Yeah.
the interests of the voyage.
Yeah, I just want to also probably, to mention that they are not really a convention. They are not really, mandatory in nature. So they are just basically applying to the contract by reference.
Right, the
But
contract will have to reference them and incorporate them, and
Mhm.
the York Antwerp rules are maintained. They were by the Comité Maritime International.
Yeah.
They have working groups that develop new concepts, that develop new sets of rules. There's a 2004 York Antwerp rules that was developed by the CMI working groups from 1994 to 2004, and then industry has to accept it and become familiar with it. That takes a long time. It takes a process that sometimes it happens quickly and sometimes it never happens. So the 1994 rules, I believe, are more popularly adopted and favored by, say, P&I clubs and owners, and are incorporated into their bills of lading, whereas the 2004 rules are less popular, even though they are an update and something that was supposed to be an improvement over the 1994 rules. And then we have some rules in 2016 that were more of an amendment to the York Antwerp rules.
Yeah. Well, and just to close this this subject about the general average itself, I mean, can you comment a little bit on how could be the procedure and calculation? I mean, how it actually work in a usual case from your perspective? Obviously not in detail, but I mean, what can you tell us about this?
Well, usually what happens is the owner, or in this case, uh, the charterer who's issued the bills of lading, decides that makes a declaration of general average. And that's sort of a notice to all the cargo interests that there's going to be a claim. We've had a sacrifice. We have a voyage that we want to continue, and we are going to ask you that to contribute to these common expenses as a condition of us completing the voyage and delivering you your cargo. So so the ship owner declares general average, gives notice to all the cargo interests, and then appoints an average adjuster.
Mhm.
And the average adjuster gets to work right away to identify all of the different cargo interests that need to post security. And I believe that they reach out to the different a lot of different underwriters, cargo underwriters, for the that know that they have cargo on a particular vessel that's been involved in a casualty, and start collecting that security and adding up, everyone that has paid and people that need to be contacted, and either have their underwriters pay or have them post their own individual security. Then the average adjuster has a very arduous process of collecting information on the damages, and it takes anywhere from 18 months to 2 or 3 years for the average adjuster to get all of that documentation, do all the calculations, and come up with the general average statement. And like I was saying earlier, that statement might come 3, 4, 5 years after a casualty. It'll be incredibly detailed, very helpful actually when you are fighting damages in a case. If you have that average adjustments input on the different claims and the expenses and the parties involved. But initially, there's some initial activity to notify cargo interests, to collect that security, to start documenting the claim by the average adjuster, and then you don't hear from them. The average adjuster has his work to do, and he goes about that while the litigation continues between the private parties to allocate fault and assess damages and litigate the case.
Hmm. What do you think is the way forward with this? I mean, what do you think about the people who is trying to claim, from economic loss and stuff like this? What do you think is like what's going to happen with this?
Oh, well, I mean, claims for economic loss are being talked about throughout Baltimore, the city of Baltimore and the state of Maryland. And there are a number of parties that are alleging they've been damaged because the because the port was closed, so they were stuck inside the port and they missed out on contracts, or they had economic losses, or they had they suffered business damages, business loss, business interruption damages as a result of this casualty. And that type of claim under U.S. maritime law is typically not allowed. It's barred by the Robbins Dry Dock principle, which is a 1920 U.S. Supreme Court case that held that in order to recover an economic loss under maritime law, you have to have a physical damage. So for entities for companies that were impacted by the closure of the port and that suffered business type damages that seek to recover those from the ship owner in the limitation of liability action are going to be subject to motions to dismiss under Robbins Dry Dock that they have purely economic losses, and it's a bright line rule where they're not allowed under U.S. maritime law.
Okay, so it's a bumpy road there, probably for them.
Not good, not good for the business damage claimants in Baltimore. But they're creative lawyers. They may find ways around it. They may find exceptions. I mean, that's what happens in a situation like this when you have a case that tests the limits of, for example, our Limitation Act. This is when everybody pays attention to the Limitation Act because they see a huge liability like the bridge, and they're concerned that a ship owner would get away with not compensating people for those damages. But the law has a way of being worked to resolve those issues. And well, I mean, one thing I can say about the limitation of liability, our Limitation of Liability Act, it's flexible enough to give way when there's a big incident like this. And it does that by the privity and knowledge exception. So that if the owner had privity and knowledge of the defective condition or what caused the accident to occur, that's going to break the limitation and require full liability for the owner. And that will be a hotly contested battle, especially in a case like this, where they're pointing to crew negligence. And when it's just that those crew members operating on board a vessel,
They will not be
the
under,
knowledge to come back to the owner, has to be by a pre-existing condition or other work that pre-existed the voyage, and not just an error of navigation, because an error of navigation will exonerate the owner under the contract of carriage and under the Limitation Act. So that's those are the two sides of the battle that will be fought very extensively over the next several years.
Yeah, probably you will have that discussion about the alter ego of the ship owner for that privity concept as well. I don't know if you have that, the alter ego, like who is the
alter ego?
Yeah, the alter
we do have alter ego concept when a company or when an individual is hiding behind the corporate formalities. But that usually, the alter ego doesn't usually come into play with the Limitation Act.
Okay.
Because it's supposed to be the registered owner, the interest that owns the vessel. And those are often, single purpose corporations set up just to own the vessel. but in order to operate, they typically have to have the P&I Club insurance, and the P&I Club insurance gives you that, you know, 1 billion plus liability coverage.
Mhm.
So whether you're a single purpose corporation or a large, just a large conglomerate operation, they're going to have access to liability
Sure, sure.
for large cases like this.
Yeah. No, I was just thinking about what you were saying about, that the owner with the privity of and knowledge of what, in order to operate the limitation. I mean, what you were mentioning about the Limitation Act.
Yeah.
Um,
Right. Well, it
but
includes the owner and the owner pro hac vice. So it has to include the company that mans and operates and, feeds everyone on board and is responsible for all the maintenance. Both those two companies, those two entities, are both entitled to limit and subject to having their limitation broken.
yeah. But at the end of the day, I mean, the economic loss is not admitted. So, I mean, that's also outside the scope, as you have said, probably
Not
creative.
not under general maritime law, but there may be Maryland state law where they can proceed against the owners of the vessel, um,
Oh, well,
or try to avoid the limitation. I don't know if they can proceed against the owners because there's an order in place, a restraining order restraining anyone from filing suits anywhere but the federal litigation in Baltimore.
yeah. Well, that makes sense, right? Otherwise, will be very difficult. And
That's how you protect the owner's limitation of liability, by
yeah,
requiring all the claims to be filed in one jurisdiction.
yeah,
And that is a huge benefit to the owner to not have to fight this battle in 28 different forums.
yeah. Well, probably if that will not work that way, a lot of people will not be interested in going, to the navigation activity. So, I mean, at the end, it makes sense. Probably we
True.
should also mention that United States is not a party to the LLMC, right? To the Limitation
We're
Convention.
not. We're not a party to the LLMC or the
System.
Collision Convention or a lot of conventions. So that's why I refer to our 1851 Ship Owners Limitation of Liability Act.
Yeah, I've seen so many like newspapers and stuff were making reference to the like the Titanic sort of.
Yes, right. Because the Titanic, the post-incident value of the vessel was basically the lifeboats that were saved because the ship sank. So, that's what they put up. That's what they were required to put up under the Ship Owners Limitation of Liability Act as the value of the vessel. So it
Yeah.
was, a small percentage of the total Titanic cruise ship that sank, just the lifeboats. And I think they actually did limit liability to the value of the lifeboats.
Now, in your experience, I mean, this kind of limitation is usually successful in U.S. maritime cases?
No, not they're not favored by this limitation act is not favored by judges typically, because it does tend to deny compensation to people and claimants that are injured. I mean, they will follow it, but the privity and knowledge exception is where judges can be more creative to try to get around what might otherwise be a limitation.
Well, it seems to be that it's a wait and see situation. Don't you agree?
Yeah. Well, yes, and or maybe update your Limitation of Liability Act if you can get the U.S. interests aligned. I
Yeah.
think maybe it's time
What do you think about that? Do you think they
to
are?
join the rest of the modern transportation world and update our Limitation of Liability Act. I mean, I
Yeah.
think it works. It works, so that's why it's so hard to fix it. A lot of people don't want to hear about it until there's a major incident like this bridge collision, and then it will get some political momentum and some attention that might allow us to get a more
Discuss.
updated regime.
Yeah, at least to have the discussion, right?
Right.
Well,
Has to be a disaster. That's when things happen.
yeah, sadly. Sometimes we, as you know, humans, we need a tragedy to discuss these kind of things. Well, thank you very much, Vincent, for being with us for half the time today to talk to our audience here in the region and to explain a little bit about the whole concept of Alician, general average, and some aspects of this very important and delicate case. So hopefully we'll see you again in some other Carta Nautica session in the future. So we hope to be around.
Okay, well, thank you very much, Javier. Good to talk with you and all of your colleagues on the webinar. And I appreciate the opportunity